Gifford Collins. I own Collins Law Firm LLC, and I'm an estate planning and business succession planning law firm. We help families build, protect, and efficiently pass their wealth on to the next generation. So, and I'm chatting with Michelle today, and she is a social worker for a healthcare provider in the area. And I'll let her introduce herself here in a second, but the purpose of the call is I routinely work with clients on producing healthcare powers of attorney and advanced directives, directions to doctors about end-of-life circumstances. And I feel I'm well versed in the way that they work, but I realize that, I don't have the on-the-ground, where the rubber meets the road type of experience that a social worker in a healthcare provider setting would have. So personally for me, I thought it'd be beneficial to chat with a social worker. And luckily my wife is a social worker, and she was able to put me in touch with Michelle. And here we are. So I hope this is educational for myself and hopefully for my clients. So please, Michelle, introduce yourself and give us some background.
My name is Michelle Whalen. Like you said, I'm a social worker in the medical field, medical social worker. I work in an inpatient unit, one of the hospitals here in Milwaukee. My unit specifically is general medicine, so we see a bit of everything from really complex patients to more routine patients. So I work there, and that's kind of what I do. I work with patients on a day-to-day basis with their healthcare power of attorneys. It's really part of our initial assessment. I touch every patient that comes onto my unit, and one of the questions I ask every patient that comes in is if they have a healthcare power of attorney, if they're interested in completing one, and we're able to do that with patients who haven't had one completed while they're at the hospital as well. So from a medical social worker standpoint, there's a lot of different social workers that work in the unit, both outpatient and inpatient. So I see a lot of the patients that come that have been admitted to the hospital for inpatient reasons.
Yeah, that's great. And then, so from your perspective, what do you feel are the most important reasons for having advanced directives like a healthcare power of attorney or directions to physicians about end-of-life issues?
Yeah, so I tell every patient, part of my spiel is that if you're 18 or older, you should have a healthcare power of attorney, regardless of what your medical needs are. A lot of people think when you start those conversations, it's meaning that they're having major medical issues or end of life discussions, but it's really something that anyone 18 or older should have. We see it really as a source of something to have in case of an emergency, if you're unable to make those decisions for yourself. And that can happen to anyone at any age with any medical condition or not. And being able to have your family have the power to make decisions on your behalf, but also help with you after leaving the hospital and making decisions even further on after that. So it's really something that it's kind of like a security for you and your family to have in place. It lays dormant and never gets touched unless it needs to. So I always preach it to anyone who's 18 or older to have on file. I have one, my husband have one, I make all my family do it. So
that's good.
Yeah, for it.
Have you ever been in a situation where decisions had to be made for someone, but they did not have a healthcare power of attorney in place?
Yeah. So
and what does that look like?
Yeah, so in that case, Wisconsin has, people often think that it's automatically your next of kin that makes those decisions for you, but state to state it varies. And in Wisconsin, it's not necessarily your next of kin, your spouse, that gets to make those decisions. It falls down to family consensus. So it comes to a lot of family members that are involved in your care, having family meetings and discussions with doctors and physicians and whatnot. And so we see, as far as making those decisions, it becomes a lot more complex the more family members that are involved, as opposed to having kind of a point person who's going to make those final hard calls if needed. And then even the calls that aren't necessarily super difficult when it's not necessarily super emergent, but it's just helpful in that sense that it really, instead of involving an entire family consensus, there's a point person to be able to help. And families always consult with each other for the most part, regardless.
Yeah.
where we see it comes into an issue a lot of the times, especially if a patient is leaving the hospital and they don't have a healthcare power of attorney, but they've been deemed by the doctors to be what they call incapacitated or not able to be their own person to make their own decisions. If
Right.
that patient needs to go to some type of a placement like a subacute rehab for strengthening or a skilled nursing facility or a memory care, assisted living, anything like that, that patient is not able to sign themselves in if they've been incapacitated, and a family member cannot do it unless they are the power of attorney or a guardian. So a lot of the times we run into families who then get stuck in a situation where they're pursuing guardianship through attorneys, through the courts. It costs a lot of money. It can be very complex. And so having that power of attorney really avoids that if it were to come to that.
Got it. And then, so does, typically healthcare powers of attorney also have HIPAA provisions in there? Is there anything that you could expand on as far as, some of the hiccups that people might run into if they don't have a HIPAA release or those type of provisions in their healthcare power of attorney?
Yeah, so what we see, and I don't know if this is kind of what you're referring to, is one thing that we see a lot when it comes to HIPAA and power of attorneys is family members thinking just because they're the power of attorney, they automatically get any medical information they want on someone, which is not necessarily the case.
Right.
If that person has not been incapacitated. Like I said, it remains dormant, so that person, the patient, still needs to give consent for us to talk to any family members at that point. But part of the piece too is that the medical team then, in discussing medical issues, if they do have an activated power of attorney, it's called activated if that patient is incapacitated, then they're able to share that medical information with family members, where without that, they're not necessarily able to do that.
Your thoughts on age differences in the healthcare setting?
Yeah, so a lot of what we see, like, I said, people always think you don't need it if you're not old or sick, but you do regardless. One of the things that, at least from a young person's perspective, when I'm talking to a young patient about completing this, I kind of let them know that emergencies can happen to anyone, right? The other piece is there's one of the questions within the power of attorney related to medical decisions being made for pregnancy. So if a patient is pregnant of childbearing age of, that time, that's a whole nother question if a family member is able to make decisions for you if you are pregnant.
Right. Yeah, that's very important.
Yeah.
Especially for younger folks, right?
Yeah. And the other thing is I always tell patients too, if they're young, this document can be changed at any time. It can be adjusted at any time. So, if you have it as your parents at one point, but then they're no longer, you can always remake that document. And the most valid document is going to be the one that's the most recently dated. And so there's a lot of pieces on the document, and there's varying documents out there, but the main one, the State of Wisconsin Department of Health Services that I use, you can write stuff in, you can choose not to write stuff in. It's something that can really be changed as your conditions change, as your needs change, as your life's changing.
Got it. So, one of the documents that I get the most questions on, and folks are usually more concerned with, is the living will, or the directive to physicians, because it specifically asks about life-sustaining procedures used in two situations, like eternal condition or persistent vegetative state. And it seems that most of the older folks are just go ahead and pull the plug, but younger folks usually will say, well, can they hold on for a year or not? But when you do get those kind of questions from younger folks in an advanced directive related to eternal condition or persistent vegetative state, how do you usually respond to those type of questions?
So typically in my conversations, and not being a medical professional, right, I don't know all the details of all that you're in that state, but I always tell patients, when you're naming a power of attorney, have those conversations with your power of attorney that you're naming on what you would want. You're able to write that stuff into the document as well, so that there's spots there, but I always tell patients, make sure that your family member or friend or whoever you're naming knows what your wishes would be, because that's something that I think is really important, but also to have those discussions as you're able with your doctors, so that they're aware, it's on file. You can complete whether you want it to be what's called your code status, to be a do not resuscitate status or a full code status. Having those conversations when you're not in an emergent situation, I think is really important. So that's kind of how I always preface that. I always say, make sure your family members or friends know what your wishes would be, but make sure the medical teams and the doctors know too.
Yeah, and have you ever run into scenarios, I'm sure you have, where people have not had those type of conversations with the agents they've appointed, and how has that resulted?
Yeah, we definitely have had those situations, to the extent where, one, they weren't sure what their wishes were, but two, that they didn't even know they were being named the agent. So we've run into that, a handful of times, which is always difficult, and I think it makes it a lot harder on that person making those decisions. And that's kind of, it's always a security. The more information you can share and the more open you can have with your doctors and with your agent who you're naming as your power of attorney, I think the less pressure it takes off of that person. So it can be difficult. I've had situations where agents have removed themselves from being the responsible person. There's always, primary, secondary, three, you can name as many people as you like, and we would then defer to the next person that you had identified. But we've run into situations where, when we have a power of attorney and we need to go to that person and that person has been refusing to make those decisions, sometimes we'll run into moving towards that guardianship process as well. So it's not the norm, but it's part of kind of why I always say, make sure you talk to whoever you're naming, but also give them a copy of the document that you create.
Right. Well, good. I feel like a lot of what's being communicated from the legal community and the health community is pretty consistent. There's guidance, I believe, both from the DHS, Department of Health, and then also, the State Bar of Wisconsin about these type of forms. And again, none, like you mentioned, none of this information is meant to be professional advice, just, kind of talk about generally some of the situations that you might run into and why you need a healthcare power of attorney. So, those are generally, from a healthcare perspective, the documents we use: healthcare power of attorney, HIPAA releases, and then the living wills for the terminal conditions and the persistent vegetative states. So, just as kind of a parting comment, is there anything generally that just from your perspective and like why you do what you do and why you feel it's fulfilling, and that advice from yourself that you usually say to folks that you're interacting with?
Yeah, like I said, I let every patient know that we have this discussion. Sometimes patients are not comfortable at this time creating document when they're in the hospital or whatnot. And, you can always go on the State of Wisconsin Department of Health Services. We'll give patients handouts about kind of the instructions on how to complete it, who you need as witnesses to do it. And it's something that doesn't necessarily need to be done in a hospital with a social worker or even with an attorney for the healthcare power of attorney. So there's a lot of, I think people can empower themselves to find, what they need that's out there, and it's a lot simpler. But mostly it's a gift to your family when you're in a situation that you don't have control over and they don't have control over. It really just makes a hard situation easier for families to deal with. And so that's kind of how I always preface that to patients.
And then finally, we're in very interesting times right now. So I think we talked generally about, you getting into work right now, but have you seen any kind of COVID-19 specific issues that have come up?
Yeah, I think we've had a lot of people more feeling more, motivated to complete these documents. I think realizing that, anyone can get sick and anyone can get ill and you never really know what's going to happen. We have a lot of providers, nurses, physicians, people within the healthcare department seeing the importance of these documents. So luckily we reach out to staff members who are wanting to complete them, not just patients as well. So we're seeing a lot of that. We're seeing, I think, people being more willing to have these documents on hand, which is good.
Yeah, no, that's great. I think from a lot of areas, I feel like what we're going through right now is causing people to think about a lot of different issues that, one, they either didn't have time to really consider because they were so busy with life living that they just didn't get to them. But also, you really do get a different type of perspective when there are so many unknowns out there. And it's great that we do have these tools in place in order to help people give it, exactly like what you said, give a gift to their family and help resolve these issues before there actually are these issues. And then, loved ones are the ones that need to take these steps when they're likely in a situation where they don't want to have to make these kind of decisions. So, right. From a personal standpoint, just for me, it is, especially with clients that I run into that, are in situations where these documents have already been filled out. We don't have to do a guardianship and we don't have to take some type of emergency court hearing in order to get someone appointed for these situations. It truly is a gift to your family to make sure that these things are in place and think about it ahead of time so they don't have to do it for you. Mm-hmm. So all I really want to say now is thank you so much for your time, and your perspective is great because, like I said, you, I'm sure, see 20 times as many cases as I do, especially about this specific situation. So again, I appreciate your expertise and thanks for taking the time to chat with me, and looking forward to chatting again.
Great. Yeah, you too. Thanks so much.